Hi, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about a really important thing that is worth knowing when you get arrested for a DUI offense. The need to request a DMV hearing following your arrest for a DUI. This is something that's really important whether you're being arrested for your first DUI, second, third, fourth, fifth, whatever. If you're being arrested for DUI in the state of California, you not only have to deal with the consequences in criminal court, but also with the consequences at the DMV. While the court has most jurisdiction over your liberty, your criminal record, whether you actually get found guilty of DUI as an offense, whether you get any jail time or any other types of penalties. But right off the bat, when you're arrested for DUI, the DMV has authority to consider suspending your license. The DMV can suspend your license following a DUI arrest if it is convinced that you were driving with a BAC of 0.08 or more at the time of driving. They could also suspend your license if they believe that during a lawful DUI arrest, they believe that you refused an officer's lawful request for chemical testing. This is discussed in one of our other videos, which you should probably look up. They can also suspend your license if you were under 21 at the time and you were 0.01 or more at the time of driving, or if while you're on DUI or wet reckless probation, there's a similar zero tolerance rule if you were arrested during that period and you tested with any measurable alcohol in your system. Those are the main grounds of suspension that we often deal with when someone comes to us after being arrested for a DUI. I want to talk more about just how you can go about requesting a DMV hearing and why it benefits the defense of your DUI case. California Vehicle Code section 13558 says that you can request a hearing on the fate of your license within 10 days after your DUI arrest, or 10 days within receipt of a proper notice that your license is in danger of being suspended. Normally after a DUI arrest in California, the officers are expected to serve the driver with a sheet called the DS-367. Sometimes we just call it a pink sheet because that's usually the color that it's in. It contains a lot of fine print on it, but the two big takeaways from it are, number one, your license will be suspended in about 30 days if you don't take action, number two, within 10 days of your arrest. The point of this is that if you want to stop your license from getting suspended automatically following a DUI arrest, it's really important to contact the DMV within those 10 days and to do so in a specific way. What we usually do is we contact the DMV on behalf of our clients in writing. And when we do that, we create a paper trail, we get a fax confirmation, all the timing is perfectly lined up to confirm that that 10-day deadline was met. But you can also contact the DMV via phone. There's a 916 area code number that's at the top of that DS-367 that goes to one of the DMV locations in Sacramento called the Mandatory Actions Unit. If you haven't retained counsel within those first 10 days, it's a really good idea to call that number as soon as possible and do your best to schedule a hearing. And be stern with any of the clerks that you're on the line with. If they try to tell you, hey, are you contesting whether or not you were actually above 0.08 or not? Sometimes people might feel the pressure and think, oh, I remember that breath test. It put me well high over that limit. Why am I requesting a hearing? Be firm about it. Once you request a hearing, it's the DMV's burden to prove that there is some ground of suspension. So on that note, I'm going to talk more directly about the benefits of just requesting that DMV hearing. Number one, you stop the DMV from suspending your license based on whatever happened at that DUI arrest. That's really important, even if your license is already suspended, or even if you didn't have a license to begin with. By stopping that suspension from happening immediately, you're able to probably better navigate whatever other problems you have with the DMV. If, for example, you didn't have a license at the time, you're still in jeopardy of being suspended by having the DMV just preventing you from getting a license for whatever the relevant suspension time would be. If, however, you're caught driving without a license in addition to DUI, by contacting DMV within 10 days, you retain the right to still get a license normally in the normal course of business. So if you were about to get a license, but you got arrested for DUI before you actually took the test or something like that, you set yourself up to still get your license in the normal course by contacting the DMV on time. It's also helpful because if you stop the DMV from issuing a suspension at that time, you also make sure you don't get caught in the trap of the courts and the DMV causing different suspension triggering events at different times. Being found guilty of DUI in the criminal courts would often trigger a suspension on its own. If you let the DMV suspend you early and then you resolve your criminal case much, much later, you're in a difficult position because you're serving 2 different suspension periods at different times. When you contact the DMV ahead of time, you retain the hope that if you do have to suffer a suspension, any suspension time runs perfectly concurrent with each other, or at least you have the ability to do that by scheduling the DMV hearing and timing it in a way that is consistent with however your criminal course is running. Furthermore, another benefit is that it can give you and your attorneys a jump start on preparation and investigation. When you reserve a hearing at the DMV, that triggers your right to what's called discovery. Similar in criminal court, if the government wants to take something away from you, like find you guilty, if the government wants to suspend your license, they have to propound upon you discovery or information that they may build their case on. Layman's terms, you can get a copy of the police report early, courtesy of the DMV, perhaps before the criminal court proceedings have started, and you can get more prepared in that way. Or by virtue of having a DMV hearing set up, you're able to use the DMV's subpoena power to get a hold of, for example, calibration records or video that may not be coming through the criminal court channels as quickly as you'd like, depending on what county that you're in. And furthermore, you can use the DMV's subpoena power and their hearing procedures to interrogate government witnesses at the DMV hearing under oath and on the record without the DA in criminal court necessarily knowing about that. This could become a huge advantage. For example, if you have a case where the toxicology is suspect, or the timing of whether or not you were driving versus when you were impaired is a little bit iffy, using the DMV hearing could be a really good way for you and your lawyer to aggressively litigate the case without the DMV knowing. And then when you go to criminal court, you can maybe have a transcript saying, hey, this is what was testified to at the DMV hearing. Have a look at this, and that can be usable in criminal court if you go to trial or a motion to suppress or just a negotiation strategy. And maybe it forms the basis to convince the DA's office to dismiss or reduce your case. Basically, you become better prepared for criminal court by virtue of having good DMV representation as well. So the big takeaway is that even if you think the writing is on the wall, or if you didn't have a license to begin with, or your license is already suspended, it's always a good idea to act promptly within those first 10 days after your DUI arrest to secure a DMV hearing properly. It always makes your case a little bit better to handle. And another common mistake, you have to contact the DMV in that specific way. We always contact mandatory actions in writing. You can do so via phone with the numbers provided to you. Do not just go to a regular DMV field office. The clerks there may not have the right information to answer your questions and actually set up the legal proceeding that preserves your driving privileges and allows you to litigate a DMV hearing in the near future. The mandatory actions unit has to be contacted. Have a lawyer do it for you, or do it yourself by calling as soon as possible, but always act quickly following that arrest. I hope this is helpful. Thanks, and stay safe out there.